All right, good morning, everyone. Today is Friday, February 26, 2021. We have 4 bills on the docket this morning. Good morning to all the JPR members. It seems like we were just together because, well, we were. With that, we'll get started with the former member of the Judicial Proceedings Committee. We'll start off with Senator Reedy with Senate Bill 613. We'll then go to Senate Bill 581, 582, and then 625. So with that, Senator Reedy, the floor is yours. Always good to see you.
Thank you. I'm sorry that I missed the JPR After Dark episode last night. It sounds like you guys were there pretty late, so I will try to be brief as I'm sure you're ready to get moving. This is a pretty straightforward, cut and dry bill. Senate Bill 613 increases the salary of the Sheriff of Carroll County at the beginning of the next term of office. The salary would increase gradually, first from 110 to 125 in December of 2022, and then to 140 in December of 2023. The sheriff in Carroll County, and the reason for the raise is was made the chief law enforcement officer a few years ago, and the duties of the sheriff have grown pretty extensively, including overseeing patrol functions, civil processing, court security, and the daily operations of the Carroll County Detention Center. In addition, our sheriff has really worked very hard to coordinate with the police departments in all of our towns. We have Westminster is probably our largest town. We also have Taneytown, Hampstead, and Manchester, and there's a resident sheriff's deputy in a couple of other towns. So Mount Airy as well. So really has added a lot of duties. The duties of the Carroll County Sheriff are very similar or pretty much the same to those of Harford and Frederick counties. And the salary that we're seeking to raise this to is pretty comparable to those salary levels. So we had a unanimous vote of our Senate delegation. We would respectfully request a favorable report on Senate Bill 613. And I am happy to answer any questions.
Excellent. Thank you, Senator Reedy. Looking around the room for questions, seeing none, that will conclude.
Thank you.
Actually, do you have a witness? Do you have a Luis? Sheriff DeWeese was trying to, I think we missed the login or missed the time for him. Okay. I think he's sending in testimony, but obviously he supports the the change. Understood. Well, hey, thank you very much. And then if you have any questions, he's happy to answer any questions also offline. Okay, great. Fantastic. Well, with that, that'll conclude the hearing for Senate Bill 613. Thank you, Senator Reedy. Next, we'll move on to Senate Bill 581. With just Senator Heddleman. Senator Heddleman, you are up.
Thank you, Mr. Chairman. I'm very pleased to be here today to offer before the committee Senate Bill 581, which removes the antiquated publishing requirement for legal name changes. This requirement is a holdover from the days when creditors wanted to ensure that debtors didn't abscond from their responsibilities. In today's world, financial systems trace debts through Social Security numbers, rendering the publishing of name changes to be meaningless and burdensome at best and discriminatory and dangerous at worst. This bill will help to simplify and update the name change procedures by removing only the publication requirements for those who wish to do so. It doesn't change anything else about the name change process, and it's important to note what this bill does not do. It does not alter or change any other requirements, such as crime victim notification or any existing process to apply for a name change. It does not relitigate who can or cannot petition for a name change. All the rules still apply. It simply allows an individual who has already filed a motion to change their name to waive any publication requirements. There are many individuals who would be positively impacted by the removal of this requirement. Victims of domestic abuse sometimes file for name changes to separate themselves from abusers. Today, under Maryland Rule 15-901, they are required to publish their name change in a publication of general circulation in their county of residence. Under Senate Bill 581, removing the publication requirement would assist survivors who are seeking separation and safety from their abusers. Additionally, members of the LGBTQ community who are seeking to be identified by their preferred names face challenges for simply wanting to protect themselves from public notification of a name with which they no longer identify. Not only can anyone, including potential and current employers, access and view a name history, but these records live on in the internet in perpetuity. Such public notices potentially make transgendered persons vulnerable to discrimination, intimidation, or even violence. Removing the name change publishing requirement will help keep safe transgender and non-binary people and survivors of domestic violence who wish to avoid risk and stigma, giving them the dignity and privacy they deserve. For these reasons, I ask for a favorable report of Senate Bill 581. Thank you.
Excellent. Thank you, Senator Hedelman, and thank you for this bill. It's great. We'll go on to your primary witness is CP Hoffman. So we'll go, CP, you'll have 5 minutes as the primary.
Thank
Welcome.
you. Thank you, Honorable Chair, Vice Chair, members of the committee. I am CP Hoffman. I am the legal director at Free State Justice, which is Maryland's statewide LGBTQ plus advocacy organization. Over the past decade, Free State Justice and our panel of pro bono attorneys have represented approximately 500 transgender Marylanders through the name change process. Once you count in the individuals helped by Trans Maryland, which we'll also be speaking today, as well as the legal clinics through Whitman Walker Health in DC, well over 1,000 transgender Marylanders have gone through the name change process over the past decade, plus all of the individuals who've done so on their own without assistance from our organizations. With few exceptions, our clients' greatest source of concern, anxiety, and frustration during the name change process come out of this publication requirement, which requires them to publicize their transgender status in ways that can put them at risk both now and in the future. Because many newspapers now publish legal notices online, Trans Marylanders are now just one Google search away from someone, whether that's a potential employer or a potential landlord or someone who means them harm, discovering their trans status. And because of this, the current publication requirement contributes to discrimination and violence against Trans Marylanders. Many of our clients have also experienced a history of violence and abuse from unsupportive family members, violence that's all too often centered on their status as being transgender. And many of them express a serious concern that publication will notify family members that they haven't talked to for sometimes years of their trans status and of the fact that they're moving forward with their transition, and will inspire a new round of violence and harassment against them. Although the court rules do provide a procedure where publication can be waived on motion, the waiver is ultimately at the discretion of the judge, and we've seen vast disparities from jurisdiction to jurisdiction in when those waivers are granted. There are some courts that recognize the heightened risks facing the transgender community and regularly grant publication waivers, and there are other courts where publication waivers are almost never granted. And you might think that this disparity has like a urban, rural, or partisan divide, but really that's not what we see. We often see, two courts within the same like metropolitan area responding differently just based on what local practices are. So a good example here is the Circuit Court for Montgomery County routinely grants publication waivers for transgender petitioners, but the Circuit Court for Prince George's County doesn't, and almost never does. While a decision of the Court of Appeals could clarify the rules statewide, there's a lot of problems with getting a case to the Court of Appeals in the first place. One of the big issues there is that because having accurate ID is so important to transgender individuals, it has so much of an impact on our day-to-day lives. So many people, just their primary concern is getting things through as fast as possible. And so when they're told that their petition to waive publication has been denied, they often just decide, let's just go forward with publication. I just want, my new ID as soon as possible. I don't want to wait 2 or 3 years for the Court of Appeals to decide this case. There's also a lot of disparities that we see that arise out of the practices of the newspapers themselves. people are basically being subjected to whatever those local policies are for the newspapers. The most obvious way that this comes up is the cost of publication itself, which depending on the paper ranges from as little as $40 to over $150. Papers have different policies and whether they put the notices online and how long they leave them online. Some papers leave them online forever. So we had one former client, for instance, who was a university professor who had numerous publications under his name. And but yet the first result that came up on Google when you searched for him was the notice in the Daily Record of his name change. We don't think that that's fair on an ongoing basis to have this like permanent, marker of transgender status. In other cases, the publication process creates unforeseen problems because of mistakes at the newspaper. Names are routinely spelled wrong or inaccurate information is put in. When I did my own name change in Prince George's County, for instance, the newspaper stated that I was a minor child, which I am not. And I called them up and they were like, no, you're not a minor child. They fortunately had time to reprint that within. Oh, thank you. There's one last thing, which is that also there's frequently issues getting the certificate of publication from the papers at the back end. And I've had cases where it's taken months to get that from the paper after we pay the invoice. I thank you for your time this morning and encourage a favorable report on SB 581.
Excellent. Thank you, CP. Next, we'll move on to Ezra Town.
Good morning. My name is Ezra Town, and I use the pronouns they, them, and I'm very grateful for this opportunity to speak before you today. I submit this testimony in support of 581. I do so as a non-binary trans-masculine person, an activist for trans communities in and around Montgomery County, a 16-year resident of Silver Spring, and a parent of 2 children. So my basic story is this. I legally changed my name a few years after the birth of my second child because the burden of filling out just the forms required for general parenting became intolerable. I had to write both names on there each time in order to be able to pick up my kid and other such things. But in addition to that extra time and frustration, it just became an emotional burden to see that over and over and over again, and I couldn't carry it any longer. I wanted to talk to you today about what the final costs and time that I ended up putting into that name change, which was far more than I expected. But because that was in 2015, the fees have changed significantly. So I looked into that. So the total cost to legally change my name and documentation today is just over $700. This includes costs for a name change court order, additional copies for evidentiary purposes, the updating of my birth certificate in Texas, a driver's license update, a new passport. And as CP and the other witnesses today will go over, it is incredibly easy to find evidence of my name change for free, including even the names of my children for less than $20. So all that to say is I urge the Judicial Proceedings Committee to issue a favorable report today without amendments on SB 581. The publication requirement compromises my privacy, the privacy of my children, and adds additional costs to what is already expensive and timely. Thanks so much.
Excellent. Thank you very much. Next, we'll have Lee Blinder. Yep.
Thank you so much, esteemed chair, vice chair, and committee. My name is Lee Blinder. I use they, them pronouns, and I'm the executive director of Trans Maryland. I'm speaking to you today on behalf of our organization as a proud non-binary transgender Marylander who has assisted more than 250 trans people in this last year with name and gender marker change. And we're the only Maryland organization focused on assisting trans people proceeding pro se with the legal name change process. Every day I talk to trans Marylanders from ages 18 to 75 plus who are fearful of their name change being publicized. Some of us, like myself, choose highly visible lives in order to help educate others, so that it becomes more widely known that trans people are here and we have existed since the beginning of time. That visibility should and must be a choice undertaken by free will. It should not be a transaction that one is forced into in order to live as one's true self. The trans community deserves privacy and dignity at a time of great joy, as those who want to pursue legal name change are permitted to do so without the outdated legal requirement of publication. Modernizing this rule will permit Maryland to stay competitive and attractive in the job market, bringing our practices in line with jurisdictions such as Kentucky, New Jersey, and our DMV neighbors of both Washington, D.C. and Virginia. As entrepreneurs seeking to bring new business to our state can trust that top-tier talent, which includes trans people, will not be choosing a state that wants to be left behind. None of these locations require publication for name change to no adverse effect. Many Marylanders are already afforded the opportunity to waive the publication requirement in our more populous counties, as well as many of our rural locations. So this bill merely equitizes the process in the counties where waivers are routinely denied. Each time I must tell an 18-year-old at one of the most empowering and exciting times in their life that their former name will be on the internet for the rest of their life is among the hardest conversations I have in my work. That joy and excitement at being seen is dashed and worry, fear, and embarrassment take over. I thank the committee for this time, and I ask you to please support SB 581 and the dignity of transgender Marylanders.
Thank you very much. All right, we'll now move on to Ms. Shapiro. Good to see you.
Good morning. Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee, and thank you, Senator Hedelman, for bringing this very important bill. I'm Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence, the State Domestic Violence Coalition. And we are here in support of Senate Bill 581. For a survivor of domestic violence, one of the most dangerous times is when they actually decide to leave their abuser. What this bill will do for those that have left is provide them with the anonymity and the ability to reestablish themselves separate and apart from their abuser. What Maryland Rule 15901 requires of the publication of a name change is that it must be done in their county of residence. And as already indicated, it is on the internet and there forever. So imagine most of us have regular Google alerts that are set up for different topics. And so if there's an abuser that has a name or wants to put the survivor's name into a Google alert and they've submitted a name change, that waiver publication requirement, it will come up and the abuser will now know what county they live in. We already have several protections in the state of Maryland. For example, there's the Maryland Safe at Home Address Confidentiality Program, which protects the address of survivors of domestic violence. But this publication requirement would then require the survivor to publish the request for change of name in their county of residence, undermining the very protections that the confidentiality program establishes. As already stated by Senator Hedelman, this bill does not change any of the other requirements regarding the change of name. A judge will still have to determine the merits of the request prior to this. It simply is removing the requirement that it be published. And as we've all testified to now, the requirement of publication is no longer just in a newspaper. It is on the internet and it will live on in perpetuity. And so this bill, as it relates to survivors of domestic violence, is largely about their safety, their security, and their ability to separate from their abusers. And so for all of those reasons, we're urging a favorable report on Senate Bill 581.
Excellent. Thank you very much, Ms. Shapiro. So with that concludes the panel for the proponents. We'll now switch over to the opposition panel. We have one person, perennial guest here, Mr. McAvoy. Don't see you here. So with that, thank you very much, Senator Hedelman. That'll conclude. I see a question from Senator Castley.
I'm just curious, I guess maybe, I don't know if Melanie or sponsor can respond, but so how do we address issues if we're not publishing, right? Then how do we address issues, people who need to know whatever happened to that person? How does that, in the legal sense? I mean, there's a reason for publication. There's a reason for publication. There's a reason for an open court docket. How do we address that? Is there and you know, in some of the domestic violence laws where you have you know, we change somebody's name, but the right people can go back and research that. So, I mean, I wouldn't want, for example, if I'm just a bad guy who needs to disappear because everybody's chasing me for creditors and all kind of stuff, I can claim that, you know, one of these statuses under this bill and just disappear. So what's the mechanism to prevent that from happening?
So I would like CP to address that, but I can initially address it. With regard to creditors, people use social security numbers now. And so they're not generally using names. The creditors use social security numbers. And so that's easily, well, that's accessible there.
Yeah, but if I get a judgment against you, I'm a lawyer for a plaintiff. I sue you, I get a judgment for $300,000. And I'm executing on that judgment. I'm pulling out overtime, money. I keep going after you, getting my dribs and drabs, and suddenly you disappear. I can't go and do a.
It's still in case search. So nothing has changed there.
I'm sorry, what's in case search? Tell me.
The name, the original name.
Yeah, but how do I connect the original name with the new name?
CP, can you address that? Mr. Chairman? Oh, there you go. Sorry.
Thank you. Sorry, I had to get unmuted. So you can search under the original name in case search, and that will give you the information on the case, and it will show that it's for a change of name, and you can, the practices differ slightly from county to county, but typically the docket will state what the new name is at the bottom of the docket.
Okay, so I understand it doesn't go in the newspaper, but I could.
It's still connected.
If I get a judgment against Joe Brown and I'm looking for it and I look up Joe Brown's name in the index, I'll find Joe Brown, and then somewhere I'll go down there and it will say Joe Brown action for change of name. I can then go to that action and say Joe Brown is now Jane Brown.
Yes.
And I can find and go from there.
Yes.
I just want to make sure that I'm not trying to jerk anybody around here. I just want to make sure that, you know, this is what I do for a living. I just want to make sure that I'll be able to find people.
Yeah, that connection is still made in the
document. Okay, all right.
And
that was.
For better or for worse, these are also propagated into a number of commercial databases, so that, you know, most people won't be going to case search to do this search. They'll be, you know, hiring. They'll be using a commercial database. You know, whether that's
well, that's good for the big creditors, the BGs of the world and all that, but we don't all have that luxury. Thank you.
The other thing that is important to remember is that when you file a petition for a name change, you affirm under penalty of perjury that is not for fraudulent purposes. So
I got that. I know. It's just that if I wanted to defraud you, I don't mind saying it's not for fraudulent purposes. So the whole premise of the question was, I'm trying to defraud you. Okay, that's all I got.
Just you also open yourself up to perjury process.
No, yeah, I got that. Some people don't seem to that doesn't seem to bother them though. Thank you.
All right, excellent. So looking around the committee, seeing no further questions, that will end the hearing for Senate Bill 581. Thank you, Senator Heddleman. We'll now move on to, thank you. Now we'll move on to Senate Bill 582, and that's Senator Heddleman again. You're up.
Yes, thank you. I don't have any witnesses for this bill, but I'm going to share with you a story after I tell you a little bit about what the purposes of the bill is. Many small businesses, and you may have heard of some of your constituents who are small business owners, are suffering because of COVID-19. And we're all aware of their struggle. And part of their struggle is because of the restrictions that have been placed on them through the governor's executive orders, as well as county executives and the mayor's orders, as part of an effort to control the coronavirus. Restaurants and bars and non-essential services were forced to be shuttered for quite some time, first statewide and more recently subject to the restrictions of each particular jurisdiction. Businesses have lost millions of dollars, many have been forced to close, and many are behind in rent and owe substantially for a variety of financial liabilities. It is pretty standard business practice for commercial leases to have personal guarantees in them, enabling a landlord to pursue the personal assets of the borrower if there's an inability to pay. I believe in the midst of a pandemic, when through no fault of their own, a business is forced to close and there's a forced loss of ability to pay, the government should step in to provide assistance and to help manage that process. And this bill is one such approach to addressing that. This bill says that for a set period of time, from March 23rd, 2020 to September 30th, 2020, a personal liability clause is unenforceable. If, as a result of the governor declaring a state of emergency on March 5th, which he did, the commercial tenant was required to, 1, cease serving patrons food or beverage for on-premises consumption, or 2, close to the public due to its status as a non-essential business. It doesn't say that the tenant isn't still responsible for the debt, and it doesn't say that the landlord cannot go after the debt in another way, through repossession or late fees, for example, or any variety of actions. But it does say that the personal liability clause is unenforceable. This bill is based on action that was taken in New York in response to the COVID restrictions on businesses there. And the city council enacted a bill quite similar to this one. The bill was challenged in court and it was upheld in November. We believe it is narrowly drawn and is good public policy to help our small business community during these very challenging times. And I'm happy to talk about how we can give judges some more ability here to make it even narrower and craft it to address the issues at hand, and including for the issues for smaller landlords. I want to share with you a story of a man actually who owns a business in the chairman's district. It's a man named David Fogel, and he has a coffee shop, a record store in downtown Silver Spring. And his landlord is a REIT, a real estate investment trust based out of Denver. They own thousands of buildings across the United States, and he'd never heard from his landlord in 7 years until they contacted him personally for the first time in about April 1st or April 3rd, 2020, 3 weeks after they had to close, to tell him that the rent was late. They required that he sign a non-disclosure agreement, even to begin talking to them about any sort of rent abatement. He signed it and returned it and never heard back. And it wasn't until mid-August that he heard from the landlord. And he heard, as of right now, we expect you to pay your rent in full. His situation is he has 30 some odd page lease, and they stuck in a personal guarantee clause, which I said is pretty normal standard business practice. In order to get a lease, you basically have to agree to all of these things. And even though he's in his 7th year of a 10-year lease, it allows a landlord to go after his personal assets to make sure that they've been made whole. He's paid rent for 6 years, paid the bill to space out the hundreds of thousands, to space out the space in hundreds of thousands of dollars of upfront costs. They made their money back on their part of the build out in the first year, and they're legally allowed to come at him personally to his assets. He's a father, has a family, he lives in downtown Silver Spring in a condo, but his condo, car, art, his record collection, whatever they see in value and as deep as they want to go is on the line. And it's not because he was a bad business owner or whatnot, it's because of a pandemic. And he said, in his life, this is what nightmares are made of right now. So I don't have further testimony, and I'm happy to discuss this issue, but really see this bill as one way to protect the small business people like David Fogel.
Thank you, Senator Hedelman. David Fogel's a good friend, and Bump and Grind Coffee Shop off the East-West Highway is amazing. So dare I say it's the best coffee in Silver Spring. All right. With that, that'll conclude the testimony for the proponents. We'll now switch over to the opposition panel. And Ms. May, you are up.
Thank you, Mr. Chairman and members of the committee. Lisa May from the Maryland Realtors speaking in opposition. Our landlord members are the ones that you find on Main Street, not on Wall Street. They are themselves small business owners. So that is where our concern for this type of legislation comes in. They too have been impacted by this pandemic. And most of our members are talking about the ways that they are trying very desperately to keep both their tenants and themselves afloat during this time. So we very much appreciate the intention of this bill and where Senator Heddleman is coming from. We just don't want to help one small business at the expense of another. We see this as unlikely that a landlord will be able to ultimately recover that rent, and it places their own financing of the property in jeopardy because their loans with their lenders were based in part upon having this recovery within the lease. So just in conclusion, we do want to help small businesses. We just have to protect all of them, and we don't believe that this is the right approach to do so. So thank you.
Excellent. Thank you, Ms. May. And with that, that'll conclude the testimony for Senate Bill 582. I'll turn over to the committee for questions. I see Senator Castley has a question.
Thank you. I guess really a question to Ms. May. I know this has become a big issue throughout the state, and I haven't done the research on it, but it seems that generally doesn't a guarantor have all the same defenses that the tenant would have? The personal guarantor?
You know, the ins and outs of that, I can probably get back to you.
Okay.
It really is our concern that, yes, in this bill, there is a rent recovery language, but when the tenant is an LLC, there really aren't any assets there
Right.
to
No, I get it.
recover,
But
and that's by design.
As the industry, are there analyses available on whether a tenant can assert defenses because of COVID to the landlord? Are there, acts of God or other defenses available to the commercial tenant that I was prevented from, my operation of under the lease was rendered impossible, like impossibility of performance or act of God or something? Are those defenses available? Is there a good law review article we can look at or something? I didn't see anything in the record that addresses these issues.
There's been a lot, there is a lot from the legal standpoint that has been written. Usually it addresses the constitutionality of something like this, which, as Senator Heddleman said, the court did uphold that this type of approach could be legal, but it did not get to essentially the policy questions that are the realm of all of you. I can certainly look into that and send you any information that I have. From the realtor standpoint, we do not have any just because our folks are the little guys. But I'm certain that, we can look into it and we can send you
get through other means as well. I was just curious. I haven't seen any scholarly articles or anything. I remember reading something, I think it was even from the Maryland bar of an attorney kind of raising the issue of how is this going to impact and whether these offenses would be available and that. But I haven't seen any conclusions or any court cases that said whether it just seems to me that if a tenant could assert impossibility of performance or act of God or some sort of intrusion by the government as a defense, then the personal guarantor ought to have the benefit of the same defense, right? I would think. Okay. All right. Thank you very much. I appreciate it. Thanks, Chairman.
Just to follow up briefly, one thing that some of our landlords were looking into were their own insurance policies that they have and whether this would qualify, for instance, as an act of God or something like that. And to our knowledge, they're finding that this does not qualify, even though it seems on the surface like this should be the perfect example of, an act of God that would allow landlords to make a claim against their insurance policy. The insurance companies have not seen it the same way.
Yeah. The whole constitutional thing raises fascinating issues because on the one hand, the landlord's saying constitutionally, you can't interfere with my contract on the personal guarantee. But then the tenant could also say, well, the government interfered with my personal contract on the tenant. So, you know, if we're going to ignore the Constitution, for me, ignore it for, you know, for you, ignore it. I don't say ignore it. That's an overstatement. But if the Constitution is malleable for that guy, it ought to be malleable for me too. And so, I mean, it's fascinating. I feel for the, you know, to say, well, the tenant has to eat it because the government said no. Anyway. All right. Thank you very much.
I think that we do as well.
Senator, I'd be happy to send you the case in the New York case that examines those very issues. And absolutely, I mean, I think I'm totally sympathetic to the smaller landlord also. I think nobody's asking for them to be off the hook with regard to rent at all. I mean, figure out a plan, give the judge the authority to work something else out, but don't go after their.
And that's certainly what I'm seeing in my community,
you know?
is landlords landlords and tenants are working together because nobody wants a bankruptcy or an empty space. And everybody's sort of extending and changing terms because, yeah, I mean, look, it's not like there's, it's easy to rent commercial real estate right now. You want to hold on to the tenant you got because the vacancy rates are high even without all this. And they're going to only continue to go up. So the industry's in trouble. Okay.
Right. I mean, I also want to distinguish between the smaller landlords and this big anonymous REIT from out of state that's coming after this guy's record collection, you know?
Thank you.
Thank you.
All right, thank you, Senator Castley. Looking around the Zoom room for additional questions, seeing none. Thank you, Senator Hedelman. Thank you, Ms. May. And with that, that'll conclude the hearing for Senate Bill 582. Thank you both. All right, we'll now move on to the final bill of the day. Senator Carter, Senate Bill 625. Senator Carter, floor is yours.
Good morning, members of the Judicial Proceedings Committee, the hardest working and most dedicated committee on the planet, not just the Maryland General Assembly. I really appreciate your attention to this really important bill. Senate Bill 625 is a critical step toward restorative justice, an issue that we grapple with in many different ways in many different pieces of legislation. This legislation is titled juror disqualification, but what it really is a juror re-enfranchisement bill. The legislation will re-enfranchise Marylanders who have been disenfranchised by outdated laws adopted by a bygone era. Gone are the times when Marylanders who served jail sentences of more than 1 year could not vote. Now they can vote. We have re-enfranchised them. But many of these same Marylanders still cannot serve on a jury, which is a valuable right of citizenship and a right which Maryland still takes away from our citizens who serve more than a year in jail or are convicted for conviction of a felony. And so I'm asking that simple thing, that if you can vote, you ought to have a right to serve on a jury. I have submitted lengthy testimony that walks us through Maryland's stages of re-enfranchisement when it comes to the vote and the steps that we've gone through incrementally to restore the right to serve on a jury. In 2016, when we were one of the leaders in the nation to restore the right to vote for persons convicted of felonies, and now all the other 49 states have done the same thing. I'm asking that we be leaders once again when it comes to restoring to those same persons that now have a right to vote, a right to serve on a jury. You're going to hear from people that are more expert in the criminal court process than I, so I won't belabor this, but I do want to say that I think that the opposition focuses on this concept that because there's this conviction of a felony, that this group of people somehow can't be fair and impartial. And I believe that is something that the court will mete out when it comes to the process we have called voir dire, where we know in Maryland, anyone that is biased, that can't be fair, can be struck for cause from a jury, serving on a jury. And so I don't think that should be a precursor, that I would say that unjustified concern should be serve as any type of a bar to passing this legislation. Again, if you can vote, you ought to be able to serve on a jury. We've heard so many times this year about the reports that show that Maryland incarcerates higher percentage of Black people than any other state in this country. About 75% of defendants in criminal cases are Black people, Black men. And for those reasons, we are actually depriving some people of a right to a jury representing a cross section of the community and a jury of their peers. And so I really urge us to move favorable on this bill. It is my understanding that we would be joining about 21 other states in so doing. With that, I will turn it over to my esteemed panel. Thank you.
Excellent. Thank you, Senator Carter. And for your primary witness, I have Mr. Jezik. And Mr. Jezik, as the primary, you'll have 5 minutes.
Thank you, Mr. Good morning. My name is Andrew Jezik. I am a criminal defense attorney in Montgomery County. I'm a former prosecutor. I was a prosecutor in Anne Arundel County and Montgomery County for almost 8 years. I am on the Judicial Nominating Commission in Montgomery County and the Jury Instruction Committee statewide. And I've had approximately over 100 jury trials. I'm also the former president of the Maryland Criminal Defense Attorneys Association 2 years ago. This bill is incredibly important and fair. And the focus of my testimony, ladies and gentlemen, is just number one, this bill does not have the negatives that some people might perceive that it does. It is simply good and has little bad, if no bad. The reason I say it has little bad or no bad is just what Senator Carter talked about earlier. In a jury selection process, the judge has an unlimited number of strikes for cause. So if any juror who has been in jail in, let's say, 30 years ago, for 2 years, and they are completely reformed and a leader of the community, that person would, under the present law, never even make it into the courtroom as a potential juror. That person who served 2 years ago, 2 years in jail 30 years ago, and is now reformed, would never make it into the courtroom. Under the new bill, if that person were to say, upon questioning by a prosecutor, yes, my 2 years in jail has made me permanently biased against the prosecutor, or at least a little biased against the prosecutor, then the judge would strike that juror and no harm would be done. Number two, if the judge were to find that that hypothetical juror who served in jail for 2 years, 30 years ago, and is a leader of the community now, could serve as a juror despite a little bit of prejudice against the prosecutor could then utilize one of his or her peremptory strikes to get rid of that pillar of the community if the prosecutor felt that it was appropriate, and nobody would cry foul. Just to remind the members of the panel, in murder cases, the prosecutor has 10 peremptory strikes. In the vast majority of felony cases, the prosecutor has 5 peremptory strikes. And in misdemeanor cases, in jury trials, the prosecutor has 3 strikes. So in all those types of cases, if there is a juror who shows some bias against the prosecution because of a prior incarceration 5 years ago, 30 years ago, whatever it is, the judge is highly likely to be the one to strike the juror, and the prosecutor doesn't lose peremptory strikes. And in the very unusual circumstance that the judge does not strike that person for their slight bias, the prosecutor can still strike the juror and nobody is harmed. And that's why I started with this. This has virtually no bad and only good. Now, the other thing I'd like to talk about is, in terms of having no bad, is that a lot of former inmates who are reformed are surprisingly tough on criminal defendants. And it's a lot of like how certain immigrants who came into this country legally and have become very successful tend to be somewhat tough on new immigrants and illegal immigrants. Because, and I'll explain it this way, I had a murder trial where my client was convicted of first-degree murder, acquitted of first-degree murder, but found guilty of second-degree murder. The one juror that was leading the pack for conviction was a gentleman who had served in jail and had 2 felony convictions, but he just hadn't served a year in jail before. Therefore, he made it onto the jury, and he was the hardest on my client because he had reformed and he knew in his head that second-degree murder was going to be a lot less bad than first-degree murder because of his experience. So don't just assume, ladies and gentlemen, that people who have served jail in the past are going to be tough on the prosecutor. Third thing I'd like to comment on is that it goes to my hypothetical that I mentioned earlier. The present state of the law excludes our fellow members of society who have completely reformed and are leaders in the community, our fathers, our mothers, our pastors, our lawyers. There are many lawyers in our bar who have been convicted and actually served time in jail. So I would just like to say that if a lawyer can argue in front of a jury, having been in jail for a year, certainly we would want jurors to be able to serve. Thank you very much.
Excellent. Thank you very much, Mr. Jessic. Next, we'll move on to Mr. Giannetti.
Hey, thank you very much, Mr. Chairman, Mr. Vice Chair, members of the mighty Judicial Proceedings Committee, my former committee. I'm honored to be before you. I'm John Giannetti. I'm the lobbyist for the Maryland Criminal Defense Attorneys Association, and I'm here in support of Senate Bill 625. You just heard from Andy Jessic. Andy has had quite a bit of experience with jury trials. I've done myself, in my own experience, had jury trials, even murder trials in the state. And I'd like to tell you that last year, this bill passed out of the House and was in the Senate. It was in your committee when everything at the end was being shortened. It was actually on a voting list, probably didn't get voted on, but nonetheless, this bill solves an important problem. You know, you don't have to be reminded of the protests that went on during the beginning days of the pandemic last year. And I think, you know, as a society, a lot of people have gone through and figured out, hey, do we have it within ourselves to take a look at our laws and figure out if you know, the effect of our laws have a disproportionate effect on any populations. And of course, the racial population or the racial overtones of a bill that excludes one racial population should be looked at. And there's a report that just came out a couple days ago talking about how if you take the population of America, about 7 or 8% of individuals have a felony conviction. All right. So under Maryland, those people wouldn't be eligible to be on a jury. If you take just the population of Black males, it's over 33% of Black males have a felony conviction, which means they would be ineligible, all right, to serve on a jury. So with that, you see that inequity, and there's something we can do to fix that when we can, all right? Back when I was in the legislature in the early 2000s, you know, Maryland joined and was a leader in letting people vote again if you had a felony, all right? That was groundbreaking, right? Now we're asking you to take the next step of enfranchisement. Now that all the states pretty much allow people to vote, now we're going to join 22, 23 other states that allow people to serve on juries. Right now, you serve a year, you can't serve on a jury. There's no way to get back out. Some states like Maine don't have any restrictions, no restrictions for felons on serving on juries. So it is the way, it is the movement of history. It's the right thing to do from a societal perspective to re-enfranchise an important part of our population. Thank you very much, and I hope if the committee gives us an opportunity to address some of the problems from the prosecutors, if they bring it up, hopefully we can address those. Thank you very much, committee.
Excellent. Thank you very much, Senator. Once a senator, always a senator. It's good to see you as always.
Thank you. You too.
Thanks. All right. Next, we'll have Mr. Jerishow.
Thank you, Mr. Chair and members of the committee. I'm Ronald Jerishow. I'm a former circuit court judge. I'm testifying on behalf of the Maryland Association for Justice. We submitted a written position papers, and the citations I'll mention are in that paper. Obviously, this is a bill that we support. We ask for a favorable report. Currently, anybody with more than a 1-year conviction, whether it's a misdemeanor or a felony, is prohibited from serving on a jury. The Supreme Court in 1979 said a criminal defendant's entitled to a jury of the community, from the community. And in 1997, the Court of Appeals said the same thing for Maryland. As cited in my paper in the supporting document, that a 2003 study, much like Mr. Giannetti cited, mine was from 2003, which said 6% of the adult population is excluded because of having a conviction, but 30% of Black men are excluded from serving on juries because of that. So the reasoning that we support this is that everybody who pays their debt to society ought to be permitted to serve on a jury. And there are misdemeanors that have longer than a 1-year conviction. So for example, reckless endangerment can be more than 1 year, assault conviction can be more than 1 year, second or third driving while intoxicated can be more than 1 year. And those are all misdemeanors, and those people would be excluded from serving on a jury. Therefore, we ask for a favorable report on this bill to take away those impediments to jury service. Thank you.
Excellent. Thank you very much. All right. Next, we'll have that. I think that concludes the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start off with Mr. Riley. Mr. Riley, you're up.
Thank you, Mr. Chairman, Mr. Vice Chairman, distinguished senators of JPR. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland State's Attorneys Association. We are seeking a negative report for this bill. Some things that a conviction of this type would keep you from having in the state of Maryland, even if this bill was passed, would be a CPA, license to practice medicine, many other licenses. You could not possess any type of firearm. If you wanted to take your son or daughter hunting, you could not do that with these types of convictions. But we would allow you to make the most important decisions, which is to decide the guilt or innocence of your fellow human beings. If I had a witness who was convicted of these crimes, some of these crimes, I would have to disclose that to the defense. The reason why is the defense could bring that up to the jury, indicating to the jury, you might want to take this witness's testimony with a little grain of salt because they have this convictions. Well, we would let them sit on the jury, though? It doesn't make any sense. It's really not fair to either side, the state or the defense, to have these convictions, people serving with these convictions. Also, this bill would allow you to have pending charges and sit on a jury. As you know, attorneys, particularly prosecutors, have to avoid the perception of conflict, not actual conflict, the perception of conflict. What could be more of a perception of conflict than someone who is actively having a charge in front of the same prosecutor sitting on the jury determining guilt or innocence of the person that the prosecutor is trying to convict? Wouldn't they have an incentive to be on the prosecution's side? I think they would. Now, we often talk about reenfranchisement bills and restorative justice bills, and there's often a lot of people from the community who have stories who say how these bills could help them. With exception to the senior judge, everyone who's on the proponents of this side is from the defense bar. So I ask you to consider that before your vote to see who is this bill really benefiting. Thank you for your time.
Thank you. Our next witness is Steve Rowe.
Members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of Maryland State's Attorneys Association. I've been prosecuting cases since 1984. In all fairness to Mr. Jezik, I can't remember how many cases I've tried jury. It is a lot. What I'm here to address is the pending charges that Mr. Riley associated with. And let's look at those pending charges that we oppose. If you have pending charges, let's say a drug distribution charge, and you have a drug distribution case that you're sitting on, one of the fair questions is if you're biased or not. Can you show bias? So the state could ask you, in voir dire, do you think you've been treated fairly by the police in your present case? Well, Mr. Jezik, the judge, Mr. Riley, everybody be jumping up and down and saying that could affect their case of a Fifth Amendment right not to ask that question. So it creates a whole new can of worms, for lack of better words, for those that are pending charges, asking if they've been treated fairly by the police in their pending case to see if they would be biased or not in the case that they'd be sitting on as jurors. So that's not fair to the defendant. It's not fair to the state. You cannot ask that question at all. So the bill that says that pending charges can be allowed to sit is really not fair to anybody. To answer Mr. Jessic's question, for murder cases, yeah, the state gets 10 strikes. The defense gets 20. Here the state gets 5 strikes, the defense gets 10 for other felonies. And for misdemeanors, here the state gets 4 and the defense gets 4. But I'm really opposed and speak strongly about having people with pending charges sitting on cases and interfering with their Fifth Amendment rights and interfering with anybody else's rights. For that reason alone, we're asking for an unfavorable report as to Senate Bill 625, and I'm happy to answer any questions.
Thank you very much. Are any questions from the committee members? Senator Carter.
Thank you, Madam Acting Chair. Yeah, Mr. Kroll and other state's attorneys, I listened to your testimony, and I'll just say it's quite troubling to me because we're simply asking for the restoration of the right to serve on a jury for those very people that have a right to vote. It seems like it's parody, but with respect to what you just said, Mr. Kroll, my question is, what is the problem with leaving the decision up to the court to determine whether someone can be biased or not? There are a number of factors that are to be considered by the attorneys and by the court, and they take those things into consideration. So what is the problem with allowing a court to determine whether someone can be fair or is biased? I mean, we come to the jury pool with a vast diversity of experience. All of us in life have biases, right? We all do. And you can't ensure against people coming with biases, but you can question them to see what their perspective is on the crime, on crime generally, on policing, on credibility, and you can make a decision based on that. And if they're biased, you can strike them for cause. So I'm not understanding why you would want to put this roadblock at the front end to prohibit all of these people, particularly Black people, from being able to serve on a jury, oftentimes where the defendant is Black. Help me out.
My testimony was to pending charges. And as to pending charges, I don't care who they are. I don't want to ask them a question of were they treated fairly by the police, which could affect their pending case. I don't want to do that. I don't want to interfere with anybody's rights. So my testimony was for pending charges only, and that's where my problem is.
If pending charges were out, would you be good with everything else?
I have to take that back to the committee, so I can't. So Mr. Riley can speak to that.
So really, what I'm hearing is that I think you're really favorable with an amendment, not necessarily opposed. But on that note, I appreciate it. I've got to go. Thank you so much.
Mr. Riley, would you like to comment? Mr. Riley, do you have anything to offer? Can you unmute Mr. Riley, please?
Yes, thank you. For those of you who have done a jury trial, please try and remember what happens during voir dire. If you have pending charges, you have a criminal defendant who very well may have exercised their rights under Miranda to not speak to law enforcement. In our smaller jurisdictions, imagine the scenario: a person with a pending charge is coming up to the court with the judge who is likely to hear their case, the prosecutor who is likely to be prosecuting their case, and having to answer questions about their pending charge to both of those people. It simply wouldn't make any sense. It would be a violation of that person's right under Miranda, under the Fifth Amendment, to answer any questions.
Thank you. I think Senator Castley and then Senator West has a speak. Go ahead, Senator Castley.
Yeah, I had a question for Senator Carter, the bill sponsor, but she's eluded me. I guess I'll have to bring it up. My concern is really, I mean, the examples we're given were somebody who was convicted 30 years ago when he was 18, and now he's in his 50s. He's had an exemplary record, or she, for decades. And I'm not trying to give us any problem with that kind of a provision in there, but this would extend to somebody who is just released. And unlike service on a jury, unlike voting, we don't have a test. Your veracity, your credibility, your integrity is pretty much irrelevant in the voting system, as long as you didn't cheat to get into the polls, I suppose. Voter fraud. But we've got to I look at our criminal justice system, we necessarily encourage people to be through the system as quickly as possible, realizing we're taking a chance on them, and maybe they're have really reformed and maybe not. We don't know. We put them out and we watch them and we hope like heck, we cross our fingers and pray to God that they're going to continue on the straight and narrow, but we don't really know. And then certainly after a few years, and then with every year that passes since they were released and they toe the straight and narrow, we become more and more convinced that, hey, you actually have turned your life around. And certainly you get a couple decades out, me personally, I'm like, hey, this person's reformed. But we're going to throw people into the jury pool who have just been shown that they don't respect the law. They don't have integrity. They don't mind abusing the law. And we're going to say, now you go and take these jury instructions and abide by the law. That's a big charge to give to somebody who has only been out of jail for a year, for prison, for fraud, some kind of dishonesty, and say we're gonna now trust you to uphold the law as though you're a judge and somebody who's. It's really troubling to me that we're gonna take such a big step. I mean, this is serious stuff to kind of push that into the jury pool. And not allow some demonstration, some clear demonstration this person has in fact decided to turn their life around. And I for one wouldn't, the example that was given that Mr. Jericho gave of the person who's 30 years out, I'm with you on that one. I don't, somebody who was convicted at 18 and now they're 45 and they've, they're an exemplary person. Yeah, bring them all back in. I have no problem. We're not going to disqualify people in perpetuity, but there is that period of time after the initial conviction and sentencing and your incarceration where we all ought to be reasonably in doubt that this person is actually going to obey the law and do what the judge said and look at this and harbors no ill will towards the criminal justice system or society in general. So thank you.
Okay, Senator Grassley, did you want Andrew Jessup to address that issue?
No, I'll wait for, that's my issue. I'll throw it to Senator Carter when she gets back. I just, she was a sponsor.
Okay. Thank you, Senator West.
Yeah.
Thank you, Madam Acting Chair. I think I'm getting this terminology down these days. My question, it relates to the pending charges, and it's the constitutional issues involved. So clearly, a juror who has charges pending against him or her has Miranda rights or Fifth Amendment rights not to answer questions that might tend to incriminate him or her. I guess here's my question. So in a criminal case where you're impaneling a jury, wouldn't defense counsel have rights to ask questions of a juror which the juror would find protected under the Fifth Amendment? But doesn't the defense counsel have a right under the Constitution to put on the proper defense? Here's my question: does anybody know whether under the Constitution defense counsel would have the right to ask the sort of questions which the juror feels his Fifth Amendment rights protect him from having to answer?
Who would like to address that issue? Sandy, could you unmute Andrew Joseph, please? Sandy, just raise your hand. Oh, thank you. Okay, proceed.
Thank you, Senator, for that question. The answer to the question is that in Maryland, there is very limited voir dire. Maryland has some of the most limited power of attorneys in the country for attorneys to ask potential jurors questions. So in other words, most of the time, when I want to address a juror personally, I need to address the judge first and say, Judge, may I ask the juror the following question pertaining to X, Y, and Z?
And let's assume the judge says yes.
Right. So if the judge then says yes, then the judge will presumably limit the judge can cut me off after he or she hears my question. That's number one. Number two, the question is not about what you did or what your defense is. The question is simply, would the fact that you're charged with X, Y, and Z and it's pending in this county, would that affect your ability to be fair and impartial, given the fact that one of the charges is a gun and there's a gun in this case? So we're not getting into any of the facts of the case. We're just getting into the charges and who the prosecutor, whether it's the same jurisdiction.
Well, here's my, let me pursue this line of inquiry. So is it conceivable in Maryland the circumstance would arise in which defense counsel would want to ask the jurors, the prospective jurors, a question, and the judge says, I'm not going to allow you to ask that question of this particular juror because it would require him to, if in answering it, he might incriminate himself. And so the judge doesn't permit the question to be asked. And then would that provide defense counsel grounds for an appeal later on the grounds that defense counsel had his case or her case prejudiced because that question was not permitted to be asked during the voir dire process?
Senator, that's an excellent question. The answer is because it would in other states, but not in Maryland is my answer, because the grounds for voir dire are so limited for attorney conducted questioning during voir dire. Our right is, first of all, circumscribed by whether the judge allows us to ask. So assuming the judge allows us to ask is your question, then we are only allowed to ask related to bias. So our questions are limited on whether it can be reversed or not, on whether or not the person could be fair and impartial. So I do think that if I wanted to get into, well, sir, tell me a little bit about what happened at the key moment when the homicide victim died. You know, were you the one with the gun or was it your co-defendant? And that's important because I want to know there's a gun in this case, right? If the judge denies that ability to ask that question, that would not be grounds for an appeal because the appellate court would say that doesn't go to the ability of the juror to be fair and impartial. So
thank you very much. Let's turn to the prosecutors who were involved in these criminal cases too. Do you agree with what Mr. Jezik just said? That
Sandy, can you unmute Stephen Pearl, please? Or Joseph Riley, whoever wants to answer that question.
Whoever wants to answer, raise your hand.
I disagree with Mr. Jezik strongly.
I disagree with that as well. As Mr. Jezik knows, being a very experienced trial attorney, let's take, for example, the victim question that is current voir dire. Has anyone in the jury pool been a victim of a crime is the question. And no matter what the defendant is charged with, if people answer yes or no, they come up to the bench. Now, let's say the defendant is charged with some sort of sexual assault. If the victim who comes up there says, well, juror number 174, you answered yes to the question that you are a victim of a crime. What can you tell me about that? Is typically the question from the bench. The victim would then respond, well, I was a victim of and would describe what's going on with their case. This same question would be asked to defense. Keep in mind, we don't have a model voir dire question yet because this doesn't exist. So whatever the model voir dire question would be, it's totally theoretical. We don't know what it is. So that person would come up and say, well, you answered the question that you are currently charged with a crime. What can you tell me about that? Would probably be the question that the judge asked. And then at that point, we have a Fifth Amendment problem for that juror. And we also have a problem with a fair trial for the defendant if this person is allowed to be a juror, because the criminal defendant is charged with being a zealous advocate for his client. He must pry into these questions to make sure that there isn't any potential bias for him. Maybe he's charged, maybe he's the co-defendant, maybe he's some sort of relation to this conspiracy. Who knows? But there might be a need for him to pry further into this, and that would be a violation of the potential juror's right and not effectively serving his client. So it just
and then to conclude my question. So in such a situation, would not the defense counsel who was denied the right to pursue and ask these questions, would not the defense counsel have a ground for appeal down the road if his client was convicted because he allegedly, he was not permitted to ask the questions that defense counsel felt duty bound to ask during the voir dire process.
Absolutely, yes.
Okay, thank you.
Okay, Senator West, any other further questions? Okay, any further questions, committee members of these witnesses? Seeing none, I believe that ends the hearing on SB 625, and that is the last bill for this morning. So this concludes our hearings today until later on this afternoon. Thank you.